New York has the most complex rent increase regulatory framework in the entire United States, and it's not even close. If you own rental property in New York, understanding the layers of regulation that apply to your specific property is absolutely critical, because the penalties for overcharging rent can include massive refunds, treble damages, and attorney's fees. The governing law includes the Real Property Law, the Rent Stabilization Law of 1969, the Rent Stabilization Code, the Emergency Tenant Protection Act, and the Housing Stability and Tenant Protection Act of 2019, which fundamentally rewrote the rules for New York landlords. Let's start by identifying the different regulatory categories, because the rules that apply to your property depend entirely on which category it falls into. The first category is rent-stabilized units. Rent stabilization covers approximately 1 million apartments in New York City alone, making it the largest rent regulation program in the country. Units are generally covered if they're in buildings of 6 or more units built before January 1974, though the specific criteria are more nuanced. Rent stabilization also applies in certain counties outside of New York City, including Nassau, Westchester, and Rockland counties, where local governments have opted in under the Emergency Tenant Protection Act. For rent-stabilized units, the landlord cannot set the rent increase amount. Instead, the annual increase is determined by the Rent Guidelines Board, a 9-member body appointed by the mayor. Each year, the RGB votes on the maximum allowable percentage increase for 1-year and 2-year lease renewals. These percentages are typically modest. In recent years, the RGB has approved increases ranging from 0% to around 3 to 5% for 1-year renewals and slightly higher for 2-year renewals. In some years, the RGB has voted for a rent freeze, 0% increase, which means landlords of stabilized units cannot raise rent at all for the coming lease cycle. The RGB's decision applies to all lease renewals that take effect during the applicable period, typically from October 1st through September 30th. The landlord must offer the tenant a renewal lease at or below the RGB-approved increase. The landlord cannot charge more than the RGB-approved amount, regardless of what the market might bear. The 2019 Housing Stability and Tenant Protection Act made dramatic changes to rent stabilization. Before 2019, landlords could deregulate apartments through vacancy decontrol when the rent reached a specified threshold. This allowed landlords to remove units from rent stabilization over time by implementing vacancy increases and capital improvement surcharges until the rent exceeded the deregulation threshold. The 2019 law eliminated vacancy decontrol entirely. Once a unit is rent stabilized, it stays rent stabilized, regardless of how high the rent goes. This permanent stabilization was one of the most significant changes in the 2019 law, and means that rent-stabilized units will remain regulated indefinitely. The 2019 law also eliminated the vacancy bonus, a provision that previously allowed landlords to increase the rent by up to 20% when a rent-stabilized unit was vacated between tenancies. Landlords can no longer automatically increase rent between tenants. The rent for a new tenant in a stabilized unit is based on the prior legal regulated rent, with any applicable RGB-approved increases, not a market reset. Individual apartment improvements, known as IAIs, were also dramatically restricted by the 2019 law. Previously, landlords could make improvements to individual units and permanently increase the rent by a fraction of the improvement cost spread over the unit's lifetime. The 2019 law capped the total amount that can be added to the rent through IAIs, limited the number of IAIs during a 15-year period, and required that the increases be temporary rather than permanent, meaning the IAI surcharge must be removed from the rent after 30 years. These changes significantly reduced the financial incentive for landlords to invest in improving stabilized units. Major capital improvements, known as MCIs, were similarly restricted. MCIs are building-wide improvements like new roofs, boilers, windows, or elevators that benefit all tenants. Previously, MCI surcharges were permanent additions to the rent. Under the 2019 law, MCI surcharges are now temporary. They must be removed after 30 years. The maximum annual MCI increase was also reduced to 2% of the tenant's rent. These changes mean that the cost recovery period for major building improvements is much longer than before, which has affected landlords' investment decisions for stabilized buildings. The second category is rent-controlled units. Rent control in New York applies to an older and shrinking group of apartments, generally units in buildings built before February 1947, where the tenant or their lawful successor has been in continuous occupancy since before July 1971. There are relatively few rent-controlled units remaining, estimated at around 20,000 in New York City, but they are the most heavily regulated rental units in the state. Rent increases for rent-controlled units are determined by the maximum base rent system, which calculates allowable increases based on the building's operating costs. The process is administrative and involves filings with the Division of Housing and Community Renewal. The third category is market rate units, those that are not subject to rent stabilization or rent control. For these units, the landlord can set and raise rent based on market conditions. However, even for market rate units, the 2019 law and the statewide Just Cause framework impose procedural requirements. For market rate month-to-month tenancies, the notice period for rent increases depends on how long the tenant has been in occupancy. If the tenant has lived in the unit for less than 1 year, the landlord must provide at least 30 days' notice. If the tenant has been there for 1 to 2 years, the notice period is 60 days. And if the tenant has been there for 2 years or more, the landlord must provide at least 90 days' notice. These staggered notice periods, introduced by the 2019 law, apply statewide and represent a significant increase from the previous 30-day standard. For fixed-term leases on market rate units, the landlord must provide advance notice of non-renewal or new terms, including rent changes, based on the same staggered timeline. If the landlord fails to provide the required notice, the tenant has the right to remain at the existing rent until proper notice is given. The notice must be in writing and must clearly state the new rent amount and the effective date. New York doesn't prescribe a specific statutory form for rent increase notices on market rate units, but clarity and proper delivery are essential. Deliver by a documented method, personal delivery, certified mail, or other verifiable means. Now let's talk about New York City specifically, because the city's regulatory layers add even more complexity. New York City's rent stabilization system is administered by the Division of Housing and Community Renewal, known as DHCR, along with the Rent Guidelines Board. The DHCR handles individual complaints, overcharge cases, and administrative proceedings. If a tenant believes they are being charged more than the legal, regulated rent, they can file an overcharge complaint with the DHCR. If the complaint is sustained, the landlord may be required to refund the overcharge. And, under certain circumstances, the tenant can recover treble damages. The 2019 law extended the look-back period for overcharge claims. Previously, the DHCR could only examine the rent history for 4 years when evaluating an overcharge complaint. The 2019 law extended the examination period to 6 years, and, in cases of fraud, the DHCR can look back further. This means that rent overcharges from years ago can still be challenged, and landlords who improperly increased rent in the past remain exposed to liability. New York City also requires landlords of rent-stabilized units to register annually with the DHCR. The registration includes the legal regulated rent for each unit, and the information is available to tenants through the DHCR's online rent registration system. Failure to register can result in penalties and can affect the landlord's ability to collect rent increases. Outside of New York City, the rent regulation landscape is simpler for most landlords. The majority of upstate New York rental units are market rate, and landlords can set rents based on market conditions, subject to the statewide notice requirements based on length of tenancy. However, landlords in Nassau, Westchester, and Rockland counties should verify whether their properties are covered by the Emergency Tenant Protection Act, which extends rent stabilization to qualifying units in those jurisdictions. Rent increases, whether on stabilized or market rate units, cannot be retaliatory. New York's Real Property Law Section 223B prohibits landlords from raising rent in retaliation for a tenant exercising their legal rights. Protected activities include making a good faith complaint about habitability to a government agency, filing a complaint with the DHCR, participating in a tenants organization, and exercising any right under the landlord-tenant law. If a rent increase is implemented within 6 months of the tenant's protected activity, there may be a presumption of retaliation. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the New York Human Rights Law, found in Executive Law Article 15, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, sexual orientation, gender identity or expression, disability, familial status, marital status, age, military status, or lawful source of income. New York's anti-discrimination protections are among the broadest in the country. New York City's human rights law adds even more categories, including immigration status and status as a victim of domestic violence. The lawful source of income protection is particularly significant for rent increases. A landlord cannot raise rent specifically to push out a tenant who receives Section 8 vouchers, public assistance, or other government benefits. A rent increase that appears targeted at subsidy recipients while other tenants in comparable units are not similarly affected can result in a discrimination complaint and significant liability. From a practical standpoint, New York's rental market is extraordinarily diverse. New York City, particularly Manhattan, Brooklyn, and increasingly Queens, has some of the highest rents in the nation. The interplay between rent-stabilized and market-rate units creates a complex pricing dynamic, where stabilized tenants may pay a fraction of what market-rate tenants in the same building pay. This gap has widened over time, as market rents have increased, while stabilized rents have been constrained by RGB-approved increases. For market-rate units in New York City, landlords have significant pricing power in high-demand neighborhoods, but face the statewide notice requirements and the practical reality that large increases in a just cause eviction environment may be scrutinized. Upstate New York, including Albany, Buffalo, Rochester, Syracuse, and smaller communities, has a more affordable and less regulated rental market. Landlords in these areas have more pricing flexibility, though they must still comply with the statewide notice requirements. One critical best practice for New York landlords: know the regulatory status of every unit you own. Determine whether each unit is rent-stabilized, rent-controlled, or market rate. For stabilized units, verify the legal, regulated rent through the DHCR registration system. For market-rate units, track the tenant's length of occupancy to determine the correct notice period for increases. Operating a New York rental property without understanding which regulatory category applies is a recipe for overcharge liability. Another best practice: for rent-stabilized units, track the RGB's annual vote and implement approved increases promptly. The RGB typically votes in June for increases effective the following October. Landlords who miss the renewal cycle may lose the ability to implement that year's approved increase, which cannot be recovered later. For New York landlords with market-rate units who are considering significant increases, remember that the staggered notice requirements, 30, 60, or 90 days depending on tenancy length, require advance planning. A landlord who wants to implement a large increase on a long-term tenant needs to deliver the notice 90 days in advance, which means making pricing decisions well before the desired effective date. New York requires landlords to return the security deposit within 14 days of the tenant vacating. The deposit must be held in an interest-bearing account, and the tenant is entitled to the interest minus a small administrative fee. For rent-stabilized units, the security deposit cannot exceed 1 month's rent. These requirements apply regardless of whether the landlord is implementing a rent increase. For the complete guide to New York rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel so you stay protected in every state.